Hi, my name is Robert Shelley with Shelley Law, and my law firm assists veterinary clinics with drafting employment agreements or independent contractor agreements for Veterinary Associates. Today, I'm going to talk about how a veterinary clinic can draft a strong and successful contract for their new veterinary associates. And I'm going to talk about 5 main factors that need to go into these contracts. So the first thing is how you classify them. So are they going to be an employee or an independent contractor? The IRS publishes a 20-factor test, which kind of walks through the factors of what makes someone an employee versus an independent contractor. I find many clinics try to classify everyone as an independent contractor when they're probably not. Some of the factors involved how much say you have over their schedule, how much they're working for you, that type of thing. And if someone's working in an office 9 to 5, Monday through Friday, unlikely that they're an independent contractor. There are obvious situations where classifying someone as an independent contractor makes plenty of sense. If they are just working, intermittently at the practice, maybe one day a week or a couple days a month, then certainly it makes sense to classify them as an independent contractor. The next thing would be compensation. So how are you going to pay the new veterinary associate? So there are a number of ways you could do it. One would just be a straight base salary with no incentives. 2 could be just a net collections based agreement, meaning the veterinary associate only gets a percentage of whatever the practice collects for their personally performed services. Or you can do a hybrid of both where you have some kind of minimum guarantee and then a large portion of their compensation is also tied to productivity as well. I think that makes the most successful arrangement between the two parties. The practice is insulated from someone who's just on a straight base and they're not very productive, or as if there is some kind of incentive, it's just human nature for veterinary associate to work a little bit harder to make more money. The pro-sal method is utilized in the veterinary industry fairly regularly, and that is in the long run basically a pure productivity based agreement because they're kind of salary for each year is based upon their productivity from the last year, and then they use percentage formula and that type of thing. It's an interesting way of handling compensation for a veterinary associate, but those are probably the 3 main ways, although they're just kind of a mix of all of them. The next thing would be restrictive covenants. So for the veterinary industry, the most important thing would be the non-compete and the non-solicit. The nightmare scenario for any veterinary owner is that you bring a veterinary associate into the practice, they leave, they snag the clients, they snag key employees, and then they set up shop down the road, right? So you want to make sure that you have a strong non-compete and need to think about the length that you want, the geographic limitation of it. And then as far as the non-solicit, you want to make certain that they can't actively solicit the clients. And then they cannot hire any kind of employees. Normally it's anyone who's been employed over the last 12 months prior to the termination of the contract. And this way, it protects the practice from the kind of nightmare scenario from happening. The next thing would be malpractice insurance. In the veterinary industry, it's really not a big deal at all. Nearly everyone gets their malpractice insurance through the AVMA PLIT. It's very reasonable. And so I would say, in the veterinary kind of world, malpractice insurance is probably the least of the contract worries versus maybe like an OBGYN physician. It's maybe the most important thing just because it's so expensive. And then the last thing would be the notice required to terminate the contract. It's called without cause termination. And that simply means either party can terminate the agreement at any time for any reason with a certain amount of notice to the other party. 60 to 90 days is kind of the industry standard. If you're a practice owner, obviously the longer amount of time they have to give you notice, the more time you have to replace them. And then on the provider side, obviously you want a little bit less. That way you can switch jobs more easily. So if you take kind of those 5 things, you can make certain that the practice is insulated from having a financial disaster, and a productive relationship between the two parties. Having a clinic that wants to just kind of like put the screws to the veterinary associate in every way they can in a contract, I find is kind of counterproductive. You see a lot of turnover and unhappiness from the associates. So I think a collaborative agreement that does protect the interests of the employer is certainly the best way to go. If you have any questions or are interested in drafting a veterinary associate employment agreement or independent contractor agreement, feel free to contact my law firm at the contact information listed below in the description. If you have any questions, you can comment on the video and I will answer any questions that anyone asks. So hopefully that video was helpful and I appreciate you watching. Thanks.